Hi everyone, welcome to Group 1's presentation. Today we will learn the power of appropriation vested in the legislative branch of government. This presentation will cover 7 topics on the subject of appropriation. The topics are the need for appropriation, the appropriation law, implied limitation on appropriation, constitutional limitations on special appropriation, budget impoundment, appropriation reserves, and the pork barrel system.
Article 6, Section 29 of the Constitution states that no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. So in Testa vs. Commission Audit, Dole issued EO number 40 authorizing payment in healthcare allowance to 5,000 pesos to officials and employee of Dole. But upon post-audit, COA said that the EO has no legal basis, so does COA have discretion to examine expenditures of governmental funds? So the Supreme Court said that the COA is endowed with latitude to determine, prevent, and disallow irregular, unnecessary, unconscionable expenditures of government funds. So it has the power to ascertain whether the public funds were utilized for the purpose for which they had been intended by law, and that the COA is the guardian of public funds. So in this case, GAA should be purposeful, deliberate, and precise in its contents and stipulation. Also, the COA was correct when it held that the provisions of the GAA were not self-executory, that the execution of the GAA was still subject to a program of expenditure to be approved by the President, and such approved program of expenditure was the basis for the release of funds. So in Comelec vs. Quijano, Comelec held a bidding for the supply installations for its VRS project, and Photonica was one of the bidder who garnered the highest bidding score of 6.588 billion pesos. However, the budget appropriated by Congress was only 1 billion pesos. So here the Supreme Court said that the import of the constitutional requirement for an appropriation is to require the various agencies to limit their expenditure within the appropriations made by law. And since the bid for Photonica was way beyond the amount appropriated by law or funds certified to be available, there is no way the Comelec should enter into the contract. So in the second case, Rodeo versus Aquino, this is when President Bigniano Aquino took office and his administration noticed a sluggish growth of the economy, and the World Bank advised that the economy needed a stimulus plan, and that they came out with a program called DAP, or Disbursement Acceleration Program. So here the Supreme Court said that the DAP was merely a program by the executive and is not a fund, nor is it an appropriation, and that the DAP was a government policy or strategy designed to stimulate the economy through accelerated spending, and Congress did not need to legislate to adopt or to implement the DAP. Congress could appropriate but would have nothing more to do during the budget execution stage, and that the President, in keeping with his duty to faithfully execute the laws, had sufficient discretion during the execution of the budget to adapt the budget to changes in the country's economic situation.
Appropriation law. It is the primary and specific purpose of which is to authorize the release of public funds from the Treasury. So it means there's an authority to disburse public funds. So the power of appropriation is the spending power or the power of the purse belonging to Congress, subject only to the veto power of the President. So it carries with it the power to specify the project or activity to be funded under the appropriation law. So what is the process of the government budgeting is that first, it starts with the budget preparation. So who prepares the budget is the executive branch. So it is submitted, therefore, by the President to Congress within 30 days from the opening of the regular session of Congress. So the one who initiates the appropriation bill is the House of Representatives, subject to amendments or revision by the Senate. So this is also what we call as amendment by substitution. So the bottom line is that it must originate from the House of Representatives. So there are 2 classifications: the General Appropriation Law, which intended to provide for the financial operations of the entire government during one fiscal period. On the other hand, the Special Appropriation Law is designed for a specific purpose. This will be discussed further from the next slides. Thank you. In the case of Bilhica versus Ochoa, the National Bureau of Investigation began its probe into the allegations that the government has been defrauded of some 10 billion over the past 10 years by a syndicate using funds from the pork barrel. After criminal investigations were filed following the Napoles controversy, the Commission on Audit released its own results of a 3-year audit covering the legislator's PDAF from 2007 to 2009. The total releases amounting to billions of pesos spurred several petitions to be lodged before the Supreme Court to declare the pork barrel system as unconstitutional. So the issue in this case is that whether or not the 2013 PDAF article and all other congressional pork barrel laws similar thereto are unconstitutional considering that they violate the constitutional provision on the non-delegability of legislative power. So in this case, the court observes that the 2013 PDAF article, insofar as it confers post-enactment identification authority to individual legislators, violates the principle of non-delegability since said legislators are effectively allowed to individually exercise the power of appropriation, which is lodged in Congress. That the power to appropriate must be exercised only through legislation that is clear from Section 29, Paragraph 1, Article 6 of the 1987 Constitution.
In an implied limitation of appropriation, there are two essential requisites: that it must promote public interest and that the sum released must be determinate or determinable. To illustrate this is the case of Pascual v. Secretary of Public Works and Communication. This case is about an act containing the construction and repair of the Pasig Feeder Railroad terminals, wherein the road was situated within a private subdivision which was owned by Jose Zulueta, who at the time of the passage of the act was still a member of the Senate. Due to this, Pascual alleges that the act is invalid on the ground that it was a planned subdivision roads and that there are no government property connecting the highway. Respondent argued that the people living in a subdivision will be benefited from it, and the government gains also from donation made by the owner. Now, in this case, the question is whether incidental advantage is a valid justification for the use of public funds. The Supreme Court ruled in the negative, stating the general rule that public funds may be used if the project is designed to promote public interest. In this case, the construction would serve as a private enhancement rather than serving to promote public interest. Generally, under express or implied provision of the Constitution, public funds may be used only for public purposes. No appropriation of state funds can be made other than public interest. Another case is the case of Gingona versus Caragi. In this case, it was about the 1990 budget wherein the automatic appropriation allocated to the debt service was much higher than the Department of Education. Petitioner in this case argued that it violates the Constitution, which states that the highest budgetary priority shall be assigned to the education. Respondent argued that the petition involves pure political question. Now, the question in this case is whether the automatic appropriation of debt service being higher than the budget appropriated for the Department of Education is constitutional. The Supreme Court ruled in this case that it is constitutional because it does not thereby follow that the hands of the government are so hamstrung as to deprive it the power to respond to the imperatives of the national interest and for the attainment of other state policies or objectives. The greater the amount that was appropriated by the Congress to the debt was justified because the survival of the economy is at stake. Now, the budget appropriated to the Department of Education was the highest among the other departments. Therefore, the automatic appropriation was valid and constitutional. So it must be remembered that the appropriation must be for the promotion of the public interest or purpose, and the sum to be released must be determinate or determinable so that the National Treasurer will have a guide in releasing the public funds.
That is all to be remembered in the implied limitation.
When it comes to special appropriation measures, there are certain limitations imposed by the Constitution. First, the public purpose for which the sum is intended must be vividly specified. And second, it must be supported by funds that are actually available as certified by the National Treasurer, and in case these funds are not available, it should be raised by a corresponding revenue proposal included therein. Section 25, Article 6 of the 1987 Philippine Constitution lays down the ground rules on the General Appropriations Law. The first rule states that Congress may not increase the appropriations recommended by the President for the operation of the government as entailed by the budget. The second rule states the form, the content, and the manner of preparation of the said budget shall follow the rules prescribed by law. The third rule elucidates that no provision or enactment shall be embraced unless it relates specifically to some particular appropriation therein. The third rule was further explained in the case Garcia versus Mata, wherein the petitioner was a reserve officer who was reverted into inactive status. Due to his reversion, he was not able to receive any emolument from the armed forces of the Philippines, nor was he ever employed in the government in any capacity. Basically, he relied on paragraph 11 of the General Appropriations Act of fiscal year 1956-1957. So he wanted to compel the Secretary of National Defense, Mata, to reinstate him in the armed forces of the Philippines and that he be paid the allowances due to him from the time of his reversion. However, the Supreme Court ruled that paragraph 11 is invalid because the paragraph in question relied on the fundamental governmental policy of the calling to active duty and the reversion to inactive status of reserve officers in the AFP. It was a non appropriation item inserted into an appropriation measure in violation of the constitutional inhibition against riders to the General Appropriations Act. So basically, the purpose of the third rule is to prevent riders or irrelevant provisions included in the bill to ensure its approval. Now we shall proceed to the fourth rule, which states that the procedure for approving appropriations for Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. This is intended to prevent sub rosa appropriation by the Congress. The fifth constitutional rule on general appropriations law is the prohibition against transfer of appropriation. This rule is vividly illustrated in the case Philippine Constitution Association versus Enriquez. So here, RA 7663, also entitled An Act Appropriating Funds for the Operation of the Government of the Philippines from January 1 to December 1, 1994, was approved by the President. The President also vetoed certain of its provisions. So here, the Supreme Court upheld the presidential veto of a provision which authorized the Chief of Staff to use savings to augment the pension fund on the ground that such right is only exercised and is only limited to the President of the Philippines.
Another example of the prohibition against transfer of appropriation is the Araujo versus Aquino case. Here it was contested whether the use of Disbursement Acceleration Program or DAP and all other executive issuances allegedly implementing DAP violated the provision therein. The Supreme Court ruled that the augmentation, as defined in Article 6, Section 25, Paragraph 5 of the 1987 Constitution, and authorized within each year's General Appropriations Act or GAA, is the use of clearly identified savings in the expenditures of government departments and offices to augment clearly identified actual deficiencies within those respective government departments and offices. What augmentation is not, however, is to allocate what was not authorized as an expenditure in the GAA. The sixth rule on the General Appropriations Law is the prohibition against appropriations for sectarian benefit. Let us look at two cases where the said provision is clearly discussed and contended. The first case is in Aglipay versus Ruiz, where in May 1936, the government had authorized a special stamp issue on the occasion of the observance of the 33rd International Eucharistic Congress under the sponsorship of the Catholic Church. The petitioner, as head of the Philippine Independent Church, assailed that it violated the Constitution because it benefited a particular religion. In the instant case, the Supreme Court, on examining the background facts, discovered that although the original design of the stamp featured a Catholic chalice, this was later rejected in favor of a map of the Philippines. What was emphasized, therefore, is not the Eucharistic Congress itself, but Manila, as the seat of that Congress. The issuance of the postage stamps in question was not inspired by any sectarian denomination. The only purpose was to advertise the Philippines and attract more tourists to this country. The stamps were not issued and sold for the benefit of the Roman Catholic Church, nor were money derived from the sale of the stamps given to that church. Another case that exemplifies this rule is in Manosca versus Court of Appeals, where the petitioner assailed that the expropriation was not for public purpose, and, incidentally, that the act would constitute an application of public funds directly or indirectly for the use, benefit, or support of Iglesia ni Cristo, a religious entity. In the instant case, the Supreme Court decided that the principal purpose of the expropriation is to set up a marker essentially to recognize the distinctive contribution of the late Felix Manalo to the culture of the Philippines, rather than to commemorate his founding and leadership of the Iglesia ni Cristo. The last two general rules on appropriations law are discretionary fund and automatic reappropriation. Discretionary funds are appropriated for particular officials that shall be disbursed only for public purposes to be supported by appropriate vouchers and subject to such guidelines as may be prescribed by law. On the other hand, automatic reappropriation is if by the end of any fiscal year the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by the Congress.
After having understood the constitutional rules on the General Appropriations Law, we move on to the so-called budget impoundment that touches on the fundamental rule on separation of powers. While the exercise of impoundment by the executive through the President cannot be found in the Constitution, such an act may stem from other sources of authority, as in an exercise of veto power. Impoundment is a President's refusal or deferment of the implementation of an appropriation item. In its core, it is within the discretion of the President to desist from implementing the law if doing so would prejudice public interest. Otherwise stated, impoundment by the President is impliedly found in the provisions below. First, Section 38 of the Administration Code, where the President's discretion in favor of public interest allows him to suspend or stop further expenditure authorized in the GAA. Second, in Article 6, Section 25, Paragraph 5 of the 1987 Constitution, where those allowed to augment any item in the GAA for their respective offices are limited to the exclusive list of the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions. A couple of controversial cases illustrate the exercise of impoundment by the President. Among the many issues raised in the case of Filkensaw versus Enriquez was a clash between the executive and the legislative branches on the General Appropriations Bill of 1994, where the President moved to dissolve the CAFGU, or the Citizen Armed Force Geographical Unit. The Supreme Court ruled that the Congress did not intend to deny to the President the right to defer or reduce the spending, much less to deactivate 11,000 CAFGU members. It was held that the General Appropriations Bill of 1994 was not the proper vehicle if the intention were to dissolve the CAFGU. In short, there was no budget impoundment to speak of, and that should the President intend to dissolve the CAFGU, it must be manifested in another law, as it abrades the powers of the Commander-in-Chief as well as other existing laws on the creation of the CAFGU. In another case replete with many issues is the case of Aurelio versus Aquino III in 2014, where the petitioners asserted that the unbridled withdrawal of unobligated allotments and the retention of appropriated funds were akin to the impoundment of appropriations that could only be allowed only in the case of quote-unquote unmanageable national government budget deficit under the GAAs. The Supreme Court ruled that the withdrawal of unobligated allotments under the Disbursement Acceleration Program, or DAP, should not be regarded as impoundment because it entailed only the transfer of funds, not the retention or reduction of appropriations. There was again no impoundment on the part of the President through the DAP.
Section 37 of the Administrative Code of 1987 lays out the appropriation reserves, which authorizes the Budget Secretary to establish reserves against appropriations to provide for contingencies and emergencies which may arise during the year. These reserves are merely expenditure deferral, not suspension, since the agencies concerned can still draw on the reserves if the fiscal outlook improves.
Separation of powers. Pork barrel system is a metaphor for the appropriation of government spending for localized project, secured solely or primarily to bring money to a representative district. It has a technical term regarding legislative control of local appropriations. In Article 1, Section 7 of the Constitution, grants the President the authority to veto legislation passed by Congress. This authority is one of the most significant tools the President can employ to prevent the passage of legislation. In the cases of Belgica versus Ochoa, Lawyers Against Monopoly and Poverty versus Secretary of Budget and Management, the Philippine Constitution Association versus Enriquez, the term pork barrel politics usually refers to spending which is intended to benefit the constituent of a politician in return for their political support, either in the form of campaign, contributions, or votes. Separation of powers indulges the benefits of oneself. Governmental powers and responsibilities intentionally overlap. They are too complex and interrelated to be neatly compartmentalized. As a result, there's an inherent measure of competition and conflict among the branches of the government. Therefore, the pork barrel is unconstitutional.
To sum it all up, we have to remember the general rule provided in Article 6, Section 29, Paragraph 1 of the 1987 Constitution, where no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. We hope you learned and enjoyed our presentation.